Welcome to the Website Takedown Podcast, Domain Justice with Scott Austin.
Welcome to the Website Takedown Podcast, Domain Justice with Scott Austin, a Florida Bar board-certified intellectual property attorney and founder of the Website Takedown Guy. Scott helps business owners protect their logos, names, and digital identities from misuse and imitation online. I'm Lisa Mosby, your host, and today we're talking about trademarks. Scott will explain how they work in the digital world and why understanding your trademark strength can make or break your brand protection strategy. Welcome back, Scott. Thanks for being with me.
Well, thanks very much. It's great to be here. Great to be back for another episode of the Website Takedown Guy, Domain Justice.
Scott, what counts as trademark under the law, and how is that different from just registering a business name?
Well, it's a great question, and it sounds like an easy question. Most trademark lawyers run into this fairly frequently. A business name could be anything from the literal corporate name that they file with their specific state Secretary of State or Department of State, as we have in Florida. And that usually has a business descriptor attached to it, like Inc. or Corp. Or LTD. And that is essentially your corporate name that's filed and is of record with the state. Now, a business name, on the other hand, could be a name that you use that does not include that descriptor, and frankly should be referred to as either a DBA, fictitious name, or in some states an assumed name. And the question is, do you need to do anything about that as far as publicly tying your business name to your corporate name? And the answer, at least in some states, is yes. In Florida, for example, you need to file a fictitious name affidavit with the state so that there's an ability to tie that name without the Inc., because the whole reason for filing a corporate name is so that you get the benefit of limited liability. And that's designated by that Inc. or Corp. Or business descriptor. When you take that away, for example, if someone's got a truck and they have their name on it without Inc. or limited, just because it's much catchier to go without it, they need to know there's somebody, if that truck runs over someone, who's it attached to, who's it tied to? At least that's my short thumbnail of what that's needed. Now, beyond that are actual trademarks, which can be a business name, but they can also be a slogan. They can be a logo. They can be even a scent in certain cases, non-traditional marks, things that have been used. They've even had attempts to use, they have used sounds. The NBC chimes. NBC is one of the oldest marks on record, going back to the 20s. So anything that's used as a source identifier for your goods or services is essentially what a trademark is, but it has to be something that doesn't conflict with someone else's mark. It has to be something that is not just descriptive of your goods and service. Apple for apples isn't going to work. Apple for computers is going to work, because that's what we would consider to be a arbitrary mark. In other words, you've taken a word and used it for something else, for computers, and that's successful. There are a lot of issues that we're not, within the short time here, we're going to be able to go through the entire litany of trademark law. But trademark is really at the center of what we're talking about, and that is website takedown based on abuse of a domain to take someone's trademark, put it into their domain name, they being the respondent, the person who's abusing a domain name, and try to use that to impersonate someone else, creating a website so that users online would be misdirected, essentially, to go to that copycat, what we would typically call a copycat website. There are other ways. For example, some people use a domain name just for email and then send out emails that appear to have a similar email address, but are really not related to the mark holder. And but the whole idea with a mark is that the consuming public, the Trademark Act, is really a consumer protection statute. It's there to protect the public from someone who sends out goods with the same label, but they're not of the same quality, not of the same standard the public has come to expect. And it's very unfortunate when someone arrives at a website only to find out that they're giving their information to not the person that they've trusted over the years with that mark behind it, but instead someone totally different, someone who is not affiliated.
And Mark, a lot of companies skip registration because they think common law rights are enough. What risks come with relying only on unregistered use?
Well, that's a great question because, and I see it frequently. I serve as a panelist for several of the domain name dispute resolution providers, the World Intellectual Property Organization, or WIPO, and Forum, based in Minneapolis, Minnesota. And in looking at cases over the years, you frequently see people file and they don't have a registration. A registration with the USPTO, for example, provides statutory rights, a much stronger set of rights. But trademarks are created as a result of use, and that use can be without a registration. But then we have what we call a trademark at common law. The problem with that is, how are you going to prove when you started using it, how long you've used it, and most importantly, whether or not it's achieved what we refer to as acquired distinctiveness or secondary meaning, so that consumers, when they see those words or that slogan, think of you and your services as opposed to just a group of words. Especially this is difficult with things like dictionary words or common words, descriptive words, geographically descriptive words. But you have to demonstrate, that's the extra step. You have to demonstrate through additional evidence that you have used that mark in commerce sufficiently long enough so that it is established in the minds of consumers a secondary meaning, a meaning related to you and your services, you as the source of your services or your goods, as opposed to just a group of words. And sometimes there are designations within the Lanham Act, within the USPTO procedures that equate roughly 5 years of use. But there's additional things that you need to prove. You need to demonstrate that you've generated revenues from it, that you've actually spent money on advertising and promotion, and oftentimes people will show followers. They'll use social media as a basis to demonstrate that they have millions and millions of followers. Well, somebody out there must clearly have some understanding of their mark and that it identifies them and their services as opposed to someone else or just use in general.
And if a company wants to trademark both its name and its logo, is one more valuable than the other in terms of enforcement?
Again, it really depends on the literal part, separate from the logo. Generally, what you're looking for is distinctiveness. And if the words themselves are very plain, if they're common, if they're dictionary terms, if they're things that are in everyday usage, then you're going to need to do something to make that distinctive. For an example, IBM by itself, you wouldn't think really, what is that? But because of years and years of service and promotion and advertising and so forth, that is an acronym or a abbreviation for International Business Machines. Most people know a very, very famous logo that they created that has essentially stripes, which goes back to the years when I think cards were used in computing. And that was, I believe, designed by Paul Rand, who was a very famous graphic artist. So the point is, if you have a logo, it needs to be a distinctive logo. It needs to be something that is memorable, that really stands out. And yes, that will make your words more distinctive if they're not organically or of their own accord distinctive. But the point is, if you have a mark, you need to make it as distinctive as possible from the get-go, so that you don't have to wait years and years or use these other means of evidence to establish that it has distinctiveness through acquired distinctiveness or secondary meaning.
And with the global nature of online businesses, do US trademarks carry any weight internationally, or does each country require a separate filing?
The way that the UDRP, which is the Uniform Domain Name Dispute Resolution Policy, works, which is one of the guiding lights in terms of supporting and maintaining trademark protection and trademark rights around the world. It focuses on whether there is a registration in a country. In other words, has there been an established statutory regime so that people in some country recognize this as use as a trademark. The other thing is that many of very well-known marks are registered in numerous countries around the world. It can get quite expensive, but That's what they want to do because they may be very active with local retailing or local business outsources and so forth. They may have warehouses, they may have ways that they have terrestrial stores in those locations as well. But as far as the UDRP and domain name abuse, they're looking for at least, show us some country that's happened to demonstrate statutory rights. But it doesn't have to be in every country.
I can see how that would apply to big companies, shoe companies, clothing brands, where they'd want to register in other countries as well as their home country. With the digital marketplaces like Amazon and Etsy, they have their own branding registry systems. How does that interact with federal trademark protection?
Well, I haven't dealt much with Etsy, but there are some Amazon situations I've been involved in where their stores have used other people's marks, sometimes unknowingly, sometimes intentionally. I represented a very well-known super regional retailer for many, many years, and unfortunately, one thing that they did not sell was vitamins. And what did show up on an Amazon store one day, their mark next to vitamins. So it was something we had to move quickly to get taken down. But the point is that, and that you will often see in domain name abuse, is some new area that gets attached to a mark that typically is used for something different. It may be something that's used for cars, and then suddenly you see it used for 18-wheelers, or you see it something that's surprising. And it may be an attempt, like I said, by the abuser to essentially extend, thinking that the general user, the consumer, would think, oh, well, they've just expanded into this area. So there's just so many different ways in which domain people, bad actors, as we refer to them, try to trick consumers today, and it just keeps getting worse and worse. They get more and more UDRP cases, which again is just a thumbnail, because a lot of times people either they don't think it's worth it or they don't realize how bad it is until a customer comes to them and say, hey, I didn't realize you had that new site. And by then, you don't know what you've lost in terms of your reputation, in terms of customers, in terms of a bad reputation that may have grown from goods or services that are not of the quality that you produce being sold to someone in your name.
So, Scott, before filing anything, what kind of search or due diligence should a business do to make sure that their name isn't already in use or creating a conflict with another company?
Well, the we use when I say we, website takedown guy, the law firm it's affiliated with, PLP Law Group, uses a very good search firm that has been around for many years, and it's a national search firm. And we have great trust in their ability to do a very thorough search. We call it a comprehensive search that includes federal, as well as 50 states, as well as common law, as well as digital. It looks at all the websites, all of the domain names that may have what they consider to be confusing and similar marks. So we have to do that, and they do a great job. And then we have to read those tea leaves, so to speak, to determine if something looks like it will create a conflict, both at two stages of the application process. First, with the USPTO itself, and then subsequently with someone that comes up in that search result, whether or not they would challenge it as a third party during what we call the publication for opposition period.
And if we have folks listening today who maybe have a small business, is it too late for them to file if they're already in business? And should all small businesses file a trademark for their logo or their company name to ensure that they have it down the line? Is there a size of a company that doesn't need it and can add it later? I know that's a three-part question, but I want you to try to frame for us, when should we do this process?
Well, the short answer is as soon as possible. And the simple way is initially when you start business, even before you filed a mark, whether even if it's an intent to use mark, you can put TM as a superscript. You don't have to have an application on file even to do that. A lot of people, I believe, think they do. But at least it's putting on notice someone that you're treating this particular set of words or your business name as a trademark. That's the first step. The second step is, as quickly as possible, you need to assemble the budget so that you can file, even if it's in intent to use, even if it's something that you're still planning on producing products or starting your services, but you haven't quite yet. First of all, because it establishes priority. It means that you were the first to the trough, first in the door. And the point is that gives you a tremendous advantage if someone comes along later. It also gives you recognition to start the application process. So then you can claim a specific first use date and you have some kind of evidence that you can show, which it's a good thing to either take some kind of a snapshot of your website when it goes live, something that shows when you first started really engaging in commerce with your mark. The flip side of that is that after you do have your mark, so many people, once they have a registration, fail to add a circle R or some kind of a superscript, something that denotes, and the proper way to do it is with a circle R. There's other options, but the point is to demonstrate that's how they're using it. I've seen cases that, in fact, were lost because they really didn't demonstrate that even though they had the registration, they were treating the mark as a registered mark. And then finally, the ultimate protection is you need to continue to have some kind of a watch in place that once you have that registration, is keeping an eye out for other filings for registrations, but also is keeping an eye out for other websites or domain names that might be out there that are being registered that would conflict with your mark, so that you can get it as soon as things start to happen, as opposed to waiting until, as I said, your best customer taps you on the shoulder and says, "Hey, that's a really great website. I didn't realize you guys did that kind of work."
Scott, thank you so much for your insights today. I think we'll leave it there for now. That's it for today's episode of the Website Takedown Podcast, Domain Justice. To learn more about Scott Austin and his work protecting brands online, we invite you to visit the websitetakedownguy.com. Thanks for listening, and don't forget to like, subscribe to the show, and share this episode with someone who might need to get started with their trademark today. We'll see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.